All right, good morning, everyone. Sistambi put Ben. It seems as if we are, it's almost past, so that we can start with the hearing. So please advise when we're good to go. Right, Sistambi put Ben, are we good to go?
Good morning, Chairperson. Another 2 minutes, please, Chairperson.
Okay, sure. All right, I thought I was talking to myself. Okay, coolio.
Honorable Chairperson.
Bab Somia.
Para Shangwa.
Ach, para Somia, goeiemorgen, hoe gaan dit?
Goed meneer. Alessandro de Hak, Hans Kalamsni.
Oh, ik kan niet klaar meer.
Ja.
Right. Ons kan beginnen.
Geen klastes. Ons vergader meneer.
Dankie, achtbare voorzitter.
Nee, dat is niet ons. Ja. Laat ons gaan.
As probe.
As Asambe.
All right. Good morning.
Wat gaan dan met hier mensen nou?
Ah, je moet niet zo. Hoe vraag je? Waar gaat nou met jou?
All right, colleagues, this is proof of life. The network is very, very bad. I think, colleagues, I do want to start off with, of course, an apology for yesterday, because ESCOM quite clearly is hell-bent on derailing all of us. Even now, there are colleagues who are battling to connect.
Recording in progress.
Because of load shedding. This situation continues to be untenable and quite frankly, totally unacceptable, and an indication of a total collapse of consequence management in that load shedding continues without consequence, politically and administratively at that entity. And I think it's good and opportune that in about 2 weeks, we will be at ESCOM for an almost week-long oversight visit. And quite frankly, something has got to give. The risk of ESCOM and load shedding thereof to the economy and just the social stability and political trajectory of this country are all at risk because of ESCOM. And I think that maybe, we've over-lamented without action. And also on the other hand, quite frankly, load shedding is not a default position without consequence. It's not a willy-nilly tool, particularly when the situation is as dire as things are. And I raise this because, amongst other things, the meeting we are having this morning should really demonstrate for us whether even people who are doing business with ESCOM, they themselves have had to bear the brutal brunt of blacklisting. But quite frankly, this is an executive failure. The realities of ESCOM are an executive failure. So I am just putting that out there, that ESCOM exists as a fundamental risk to every effort at reconstructing the economy, economic growth and economic development, and the very urgent reality of job creation, revenue collection, so that we can be able to get in the money to meet the social demand and so on. Nobody's going to want to do business with a country that's just continuing on a trajectory of this careless, reckless and irresponsible outlook of failing to manage the energy realities of the country. So it's actually quite a serious matter, and something's got to give. Anyway, colleagues, good morning. Welcome. We are meeting this morning with National Treasury and the SIU. We are dealing with the blacklisting of companies. I would like to take this opportunity, to welcome you, colleagues, and the Deputy Minister of Finance who is here, and the team from National Treasury. Advocate Mutibi, the head of unit of the SIU, is present this morning. And of course, as usual, our colleagues from the AG as well are here this morning, who the AG and the SIU continue to be very constructive enablers for the committee to do its work. So I would like to, therefore, colleagues, request that we start and appreciate the work that was done yesterday by Wasomi. Thank you very much. And then we will begin with the presentation from National Treasury, and then go straight to the presentation by the SIU. Then we will field questions on both presentations so that we manage time as well, and also just to get a sense of what is happening on both ends. So Sister Ben, please enter the apologies into the record, and then we will be good to go. May I take this opportunity then to welcome everyone, and Deputy Minister, I will hand over to you, and then you will deem as you deem fit. I have been advised that the Minister is at Cabinet this morning dealing with matters. That's what I was provided to me. But anyway, DM, let me hand over to you, Masondo, to you and your team, and then we will take it from there. Thank you very much.
Ngiyabonga babuhlongwa, Hlengwa, the chairperson of SCOPA and honorable members. And I may suffer the consequence of Eskom's inability to supply electricity. I'm told that by 12 I'll be load shedded at Babuhlengwa. So in an event I get cut, but I've got plan B. But if plan B doesn't work, please bear with me. And then thanks so much for giving us this opportunity to come and present on this important issue, which is about restricting companies, popularly known as blacklisting of companies and individuals that are implicated in corruption, non-performance, and other malpractices while doing business with government. So the blacklisting is an important step in fighting corruption and to entrench a culture of good governance throughout the state and its entities. I mean, Chair, there are usually two reasons why, as you will know, why companies are blacklisted by government. The first being that when companies, suppliers, individuals of goods and services engage in corrupt and other malpractices such as non-performance and irregular activities, they get blacklisted. That's the first reason. The second reason is when a court of law has ruled that a company should be blacklisted. And the common thread in the circumstances that lead to companies being blacklisted is mainly underperformance, incomplete of projects, corruption, and it's a well-known fact that individuals, both in the private sector, in private companies, and in the state, they engage in corrupt activities. And corruption, Chair, is a major problem in our country, not only because it robs the poor of services, but it also deters investment. If investors know that they have to incur an extra cost to get certain things done, they will not invest because we're making it costly for them to put their money or retain their money in South Africa. Corruption also affects our ability to generate tax revenue. If, for instance, government officials let goods pass through the borders without paying official duties, custom duties, both the company concerned and the officials involved deny South Africans good tax revenue. Corruption also kills entrepreneurship. If a company is established yesterday and tomorrow it obtains a tender, that basically kills entrepreneurship. And how therefore does blacklisting from where we're sitting help in fighting corruption and other malpractices? Firstly, it acts as a deterrent and a punishment to those who engage in such practices. Secondly, it inspires confidence amongst companies that do business with the state, that we are fair and there is, we do business in a competitive manner with them. We are also aware, Chair, that there are instances in which poor performance by companies is as a result of poor project management. Eskom, Midupi and Kusile build program is a classic example of on how poor project management can create cost overruns leading to possible corruption. I mean, Eskom was debt was 255 billion in 2014. It increased to 450 billion in 2019, largely because of cost overrun and poor project management of these two, the building of these two power stations. And we're also aware that failure to pay in 30 days create cash flow problems, leading to companies failing to efficiently provide goods and services to the state. And I do think, Chair, we really need your support, that we honestly have to craft specific regulations that punish accounting officers who fail to pay companies within 30 days. Companies are going bankrupt every day because we have left the payment within 30 days to the whims of accounting officers who fail to pay within the prescribed time. We always speak about consequence management. I do think that we need to pay specific attention, particularly on this one, because it has huge consequences on the performance of our own companies. And some of them, they end up being blacklisted for poor performance as a result of some of the cash flow problems that they have. Chair, in the recent past, we had challenges ourselves in National Treasury associated with the vacancy rate at a higher strategic level in the department. And the colleagues who've been acting in those positions, they are doing their best to do what is expected in some of those positions. And I'm pleased, Chair and the committee, to inform you that on Monday, we've had interviews. The minister conducted the interviews for the appointment of the Chief Procurement Officer and that of the Accountant General. And I'm sure we'll have to follow the necessary processes within government to make sure that we finalize the filling of these important positions, which will also assist us in dealing with some of the challenges related to poor performance, contract management, SCM, supply management issues within the government system as a whole. So we are on track in filling these positions, and I'm certain that very soon, having followed all the next steps, we should appoint competent people to assist us with dealing with some of the issues that I've just mentioned. Honorable members, let me now hand over to the acting Chief Procurement Officer, Mr. Molefe Fani, who will go into details on the mechanics, how we administer blacklisting, including the laws and prescripts that guide us insofar as the blacklisting is concerned. Over to you, Mr. Molefe. Can you take the committee through our presentation? Thank you so much.
Thank you very much, Chair. Thank you very much, Deputy Minister. Good morning, Honorable Chair and Honorable members and officials, as well as members of public. I will share the presentation that deals with restriction of suppliers. Honorable Chair, may I have an indication that the presentation is visible on your side?
Yes, it is. You may proceed.
Thank you very much. The presentation would cover three parts. That there will be part A, which speaks to the restriction process, looking at the legal framework. There will be part B, will look at the database of restricted suppliers and the tender defaulters list. Part C will then look at what we have identified as discrepancies in the restriction of suppliers based on the current frameworks. If I may resume with part A, pieces of legislation that govern restriction. We in a nutshell have what the Public Finance Management Act, which has a number of provisions for restriction of suppliers, the general conditions of contracts with specific emphasis in section 23. We also had, Honorable Chair, honorable members, preferential procurement regulations, which were declared invalid by the Constitutional Court in the last ruling pertaining to the matter. With that, we've got the Municipal Finance Management Act, Section 112, and we also have Regulation 38 and general conditions of contract that supports the Municipal Finance Management Act, together with Circular 43. Also supporting the Public Finance Management Act is the SCM Instruction Note 3 of 2016-17, which is also under revision at the moment, as I've indicated in the last sitting of scope. If I may elaborate on specifics of these sections, legislative framework, the PFMA specifically, under general conditions of contract, Section 23 indicates that if a purchaser intends imposing a restriction on a supplier or any person associated with a supplier, the supplier will be allowed a time period of not more than 14 days to provide reasons why the envisaged restriction should not be imposed. Should the supplier fail to respond, Honorable Chair, within the stipulated time period of 14 days, the purchaser may regard the intended penalty as not being objected to and may impose it to the supplier. I think what is important is that the responsibility in terms of PFMA Section 23 is on the purchaser. The purchaser here is the accounting officer or the organ of state, or any other body or person who has been duly authorized in line with the legislations of government to provide purchasing for goods and services on behalf of government. I think what is more important here is that we give suppliers an opportunity of 14 days to state their case, and upon which the accounting officer, who's the leader within the purchasing organization, to consider the mitigations that have been put forward and make a decision whether to restrict or not to restrict. The Section 23 goes further and state that any restriction imposed on any person by the accounting officer or the accounting authority will, at the discretion of the accounting officer or the authority, also be applicable to any other enterprise or any partner, manager, director, or other person who wholly or partly exercises or control over the enterprise of the first mentioned person. What this means, Chairperson, Honorable Chairperson, Honorable Members, is that if a supplier is restricted, the accounting officer may make a decision that not only the supplier should be restricted, but the directors or owners of that enterprise should be restricted. Or that supplier should not only be restricted for that organ of state, should be restricted for the whole of government until the remedial actions are taken into consideration to uplift such a restriction. I will touch on the time period it will take for a restriction of a supplier or the directors of a supplier. So basically, the law is very clear that not only a supplier can be restricted, but the owners of such a company may be restricted as well, so that they may not do business with government moving forward. If we go further under Section 23C, these are the conditions under which such a restriction may be imposed on a supplier. If a restriction is imposed, the purchaser must, within 5 working days of such imposition, furnish the National Treasury with the following information. The emphasis here is that the purchaser, which is the accounting officer of the organ of state that is doing the purchasing, must furnish National Treasury with the information as indicated in the four bullets: the name and address of the supplier or the person that's been restricted, the date of commencement of the restriction, the period of restriction, and the reasons for the restriction. It is the responsibility of the accounting officer to ensure that all due diligence and all the supporting documentation that is required for restriction are sourced from the supplier that is envisaged for restriction. National Treasury, upon receipt of this request by the accounting officer or the purchaser, will then load in the National Treasury central database of suppliers or persons prohibited from doing business with the public sector. So National Treasury will then restrict, in the nutshell, based on the information that is received. Coupled with the Public Finance Management Act, there is an instruction note 3 of 2016-17, specifically on paragraph 7. The restriction process is rehashed. That restriction process speaks from what the PFMA has already prescribed in its sections. If no response from if there's no response, Honorable Chairperson, from the supplier who is alleged to have not complied, the accounting officer or accounting authority may regard the intended penalty as not objected to and may impose such penalty on the supplier. The accounting officer or the authority must assess the reasons provided by the supplier and take the final decision to restrict. National Treasury is very strict with regards to what the accounting officer intends to do. If the intent is to restrict, they must be very explicit, and the supporting documentation needs to come through with regards to why such a restriction will be imposed on the supplier. I may have to indicate at this point, Honorable Chair, that suppliers do not take it lightly any intent by the organs of state to restrict. They do oppose such restrictions. So it is critically important that the accounting officers and the accounting authorities are strict on application of rules and the laws that are applicable before such a restriction is imposed on a supplier. Furthermore, if the penalty is imposed, the accounting office or the accounting authority must inform the National Treasury within 7 calendar days of such a decision taken. National Treasury will then load the details on the database of prohibited suppliers, and that supplier will indeed be prohibited from doing business with organs of states or with government specifically. Preferential procurement regulations, when they were still valid, Honorable Chair, honorable members, also under Section 14, required that made requirements for National Treasury to consider the documentations the organs of state provide to us for such a restriction. The honorable members would note that the Constitutional Court has declared the preferential procurement regulations to be invalid, and the matter we are dealing with currently to ensure that government still procures goods and services, and that clarification that we require from the Constitutional Court is sought and provided for. Municipal Finance Management Act has Section 112, and that stipulates that the supply chain management policy of a municipality or municipal entity must be fair, equitable, transparent, competitive, and cost-effective, and comply with the prescribed regulation or regulatory framework for municipal supply chain management, which must cover at least the following: that the bearing of persons from participating in tendering or other bidding processes. So there is a direct pronouncement from MFMA, and there is provision made for restriction in that Section 112 of Municipal Finance Management Act. There is also stipulation in Regulation 38 that a supply chain management policy must provide measures for combating of abuse of the supply chain management system and must enable the accounting officer to reject any bids from a bidder who during the last 5 years has failed to perform. So this goes with performance of suppliers or municipal entity or any other organ of state after written notice was given to that bidder, that performance was unsatisfactory. We cannot nilly-willy just put a bearing on suppliers from providing services. We must have demonstrated that we have performance managed suppliers and that such performance management endeavors have resulted in writing, and that the final pronouncement has been made on unsatisfactory performance of the supplier by the municipal council or municipal entity or the supply chain that provides that function for municipalities. Also, the accounting officer can cancel a contract awarded to a person if the person committed any corrupt or fraudulent act during the bidding process or the execution of the contract accordingly. Further on section 38, the accounting officer must inform the National Treasury and relevant provincial treasury in writing of any actions taken in terms of section 38 of the said regulations. There are further pronouncements that are made with regards to restriction of suppliers based on numerous criteria that could be used. Section 23 of PFMA, of MFMA makes such pronouncements, as well as Circular 43. Circular 43 provides for the process to restrict which council must adopt to ensure that the restriction process is procedurally fair. When it comes to municipal space, Honorable Chair, Honorable Members, the council must endorse such a decision for restriction of suppliers in line with PFMA. When it comes to PFMA, such an endorsement needs to come from National Treasury through the PFMA provisions that are given. If we look at part B of the presentation, supplier restricted database, if I may speak to that, the accounting officer or the accounting authority or National Treasury may restrict the supplier bidder according to the applicable law. We cannot operate outside the framework of what the law allows. For any default listing of suppliers on the database, it can only happen if a court of law convicts a person of an offense as contemplated in section 12 or 13 of the Prevention and Combating Activities Act, number 12 of 2004. The court may also rule that such person's name be endorsed in the register for tender defaulters. When a person's name has been endorsed in the register, the person will be prohibited from doing business within the public sector for a period not less than 5 years and not more than 10 years. The National Treasury is empowered to determine the period of restriction, and each case will be dealt with on its own merit. What we are saying and what the Deputy Minister of Finance has alluded to is that there are two areas of making sure that any supplier that has been found to have been on the wrong side of the law is prohibited from doing business with government. Number one is through a thorough investigation through the purchaser or the organ of state with the approval of the accounting officer of the accounting authority for National Treasury to effect the restriction on that supplier. And the second one is where there's a default judgment through the court of law, which then invokes the provision of the Prevention and Combating Activities Act, which then provides that responsibility to restrict the supplier. Honorable Chair, honorable members, I must indicate at this point that National Treasury may not have sight of all the matters where such a default judgment has been meted by competent courts. What is expected of accounting officers is where accounting officers has been engaged with the courts in such matters and such a default judgment has been made. It is required of the accounting officers to inform National Treasury of such a default position so that the National Treasury may include such suppliers and such individuals on the list of defaulters as it is envisaged by various prescripts as alluded to earlier. That brings us to how we are performing as organs of states with regards to making sure that the defaulters or suppliers that are listed for restriction are dealt with accordingly and may not be able to do business with government for a period up to 10 years. If you look at our statistics at the moment, there aren't any defaulters that have been registered at National Treasury, simply because the accounting officers that have been involved in such cases have not indicated to National Treasury the need for registration of suppliers as defaulters. However, in terms of restriction of suppliers on matters that emanated from internal processes in government, we have to date 56 such companies that have been blacklisted or restricted, and there has been in total 87 directors that has been that are on the default on the restricted supplier list. We are on annual basis have suppliers and directors that fall off the list when their period of default position expires, Honorable Chair. To date, we've got 26 on 1 to 3 years, we've got 94 on 4 to 6 years, and we've got 23 on 7 to 10 years in terms of suppliers. What we found as discrepancies identified in the system at the moment is that accounting officers and authorities do not restrict suppliers for poor performance. Suppliers, contracts are cancelled, and those suppliers are given a leeway to just not perform for the contract that is cancelled, but they resurface in other contracts, or they tender for other work because they have not, the performance has not been recorded, and such a restriction given to National Treasury for restriction. It is an area that we are going to embark on based on what has been the trends in the current pronouncements in the Zondo Commission, in all other fora that we have been engaged in, where we are saying such non-performances must be thoroughly documented, and such issues be given to National Treasury. For example, we have had issues reported by ESCOM where officials were involved in corrupt activities with suppliers. If such matters are picked up, such suppliers needs to be restricted from doing business with organs of states for a certain period. Our legislative framework says for a period not less than 5 years, but not more than 10 years. The company name change after restriction. Our search functions at the moment, based on the register of companies and what the CSD Central Supplier Database that National Treasury has, do not pick up such changes in names. However, Chair, I have to qualify that if a supplier has been blacklisted under the name Molefefani and they change the name, we are able to pick up that name change when we interface with CIPC. However, if the directors go and open a different name altogether for a new entity, we are unable to link the two suppliers. But if the same directors that has been blacklisted under a different name of a supplier are the same directors that have opened a new company, when they input their ID numbers on CSD, the CSD will automatically reject those ID numbers, meaning that that company would not be registered on CSD for organs of states to utilize. So there is that double check system that we've got on CSD with regards to that, where the directors do not list themselves on the new company, but they are active on the new company. CSD and CIPC would not pick up such names, and that is the problem where most of these companies resurface, most of these directors resurface in the companies that they are operating in, and not as directors and not as owners of the companies, and we are unable to detect such in our current processes. Where organs of states become aware of such, we would want them to make us aware, and we will follow through on such a tip-off. We do have whistleblowers in the system that also indicate to us that such suppliers, such directors have resurfaced, and we do follow through on matters, but there are very, very few matters that have been reported to us in those instances. The accounting office or accounting authorities do not inform National Treasuries of cases of restriction. I have alluded to that in my presentation, and where there has been a default judgment from the courts, we run short of such a notification sent to National Treasury for National Treasury to update their records. If we do get from accounting officers and accounting authorities request for default or for restriction of suppliers, and we are not furnished with enough information to apply our minds and make sure that all the prescripts or the provisions in the prescripts have been followed, National Treasury is exposed to issues of litigation, and we do request further information. And when we do ask repetitive questions that seeks clarification, you would find that restriction is not followed through by accounting officers, leaving National Treasury hanging and unable to restrict such suppliers. Where we have such issues in the future, we will then indicate to the officials, to executive that provides oversight, that such matters are hanging and there needs to be closure with regards to that. Restricted suppliers respond to the invitation to bid, even when they are under investigations for non-performance in other areas. By the time such restrictions come through, they have already been awarded contracts, and therefore we cannot prohibit them from finalizing the work that they have been contracted to do, specifically when restriction has come through non-performance route. But where there has been a default position, we do consult with the legal entities and ask them to make pronouncements with regards to such matters. The wording used in the application to National Treasury to restrict, you would find, Honorable Chair, that accounting officers do not want to take accountability. They just recommend to National Treasury, and National Treasury must only apply their minds based on the decision that's taken by the accounting officers. I cannot emphasize that more, that accounting officers must make a decision to restrict, and National Treasury must then ensure that the prescripts have been followed properly for that restriction before they include that supplier or those owners of companies for restriction. Honorable Chair, honorable members, that concludes the presentation. We may take questions, if any at all, from the honorable members.
Okay, thank you very much, Acting Chief Procurement Officer. Let's go to the SIU, and then we will field questions jointly. So that you manage things. Advocate Mtibi, good morning and welcome, and over to you.
Good morning, Honorable Chair. I greet you, Honorable Chair, and the honorable members. I also greet the Deputy Minister, DM Masondo, the colleagues from National Treasury and colleagues from SIU, and members of the public attending. Thank you very much, Honorable Chair, for the opportunity for us to present to the Honorable Committee in terms of the process that we follow to restrict the service providers. My colleague, and perhaps just to introduce my colleagues, Honorable Chair, I'm joined by the Chief Legal Counsel, Dr. Wells, who also handles these matters, Mr. Maharaj, the Chief Program Portfolio Officer, who is also involved in the process, Mr. Lekheto, the Chief National Investigating Officer. They actually are the originators of this blacklisting from the investigation side. And of course, Mr. Khanyaho, who's the spokesperson for SIU. Honorable Chair, Mr. Maharaj will do the detailed presentation. We want to underscore what the Deputy Minister said and what the committee, this honorable committee, always says, that we need to hold those who are responsible for irregularities and wrongdoing to account. And this straddles across all areas, whether it's public sector, private sector, officials, or even service providers. So this is one such area where we really demonstrate that where there is irregularities, we are geared up to ensure that there's consequence management. Underscoring again what the Deputy Minister has already said, as we investigate, we pick up that there are corrupt activities, there are irregularities, there's underperformance of service providers, poor project management, either on the side of the officials or on the side of the service providers. And we make those findings, and those findings are then included as part of our recommendations for purposes of consequence management. In this regard, restriction of service providers, which is blacklisting. Honorable Chair, there is a very recent and living example that I really want to make. And that example is found in a ruling that was made by the Special Tribunal yesterday in a matter between the SIU and the Caledon River Properties and Magua Construction, in the matter colloquially referred to as the Bait Bridge border fence matter. In our investigation, we did find that there were deficiencies in the quality of the fence. And this is a typical example where we will, in fact, my information from the Chief National Investigating Officer is that we have considered and submitted proposals or recommendations for blacklisting in this case. With your permission, Honorable Chair, just to quote from that ruling yesterday, because all of this poor performance, corrupt activities, irregularities, in terms of who is the loser at the end, it's really quite informative to hear what the judge said yesterday. The judge says, regrettably, the biggest loser is the state and the public. They have been deprived of the variety of public, social, and economic benefits that flow from a solid border track at the Bait Bridge border and are saddled with a deficient border fence. Just to really quote from that ruling. So it is really incumbent on us to ensure that as the courts pronounce themselves as they do, us as officials have to make sure that those results that settles the public with deficient products that could have been defended or prevented, that there is indeed consequence management. I really thought I would just quote that paragraph for purposes of really bringing it out there into the light, that we are conscious that this deficiencies that settles the state and the public is as a result in many instances of poor performance, poor project management, by service providers. And therefore, we then want to really be steadfast in the process of ensuring that they are blacklisted. And at this stage, Honorable Chair, I would like to just hand over to my colleague, Mr. Maharaj, who will take the court through the Honorable Committee through our presentation. As the committee would realize that there are striking similarities in the presentation made by our colleague from the National Treasury and our presentation, simply because we're really looking at the same process. We're pronouncing on the same blacklisting process. But of course, National Treasury goes further as they really are ultimately the custodian, of this process and ensuring that those who are blacklisted are listed and that process is monitored appropriately. So to that extent, I've indicated to my colleague that he might probably just highlight to the Honorable Committee where it results in the repeating of what our colleague has said, and probably just highlight where there are differences. Mr. Maharaj, over to you, sir.
Thank you very much. Good morning, Mr. Schlengel. Good morning, members of the committee. Good morning to those attending the session this morning. Please let me know whether I'm audible and whether my presentation is.
Yes, it is. Thank you very much. It to you, Mr. Maharaj. You may proceed. Presentation is up.
Thank you, Mr. Schlengel.
Thank you
very much. I'm going to deal very briefly with the process of restriction of service providers and suppliers. And as Advocate Matindi has mentioned, I'm not going to dwell too much on what Mr. Fani has already covered in his presentation. I may just highlight one or two points where we need to make it. I must mention at the outset, when you look at this slide, that when we looked at the regulatory framework, we included the preferential policy. We are aware that the Supreme Court of Appeal declared those regulations to be invalid and then suspended the declaration.
Sorry, Chair, we're losing Mr. Maharaj.
Yeah, I was about to say, but Maharaj, as Babu Samio points out, you are losing.
This really.
I hope.
Can you hear me now?
Yeah, we can. I hope ESCOM has not visited you.
No, we don't have no shedding.
Okay, but we are losing you. All right, proceed, sir.
All right, if there is a problem, please let me know. I'll try and switch my connection. And so, as I've mentioned, we have included the preferential procurement policy framework regulation. Even though we are aware that the Supreme Court of Appeal declared those regulations to be valid and suspended the regulation, and that despite the matter being taken on by the state constitutional court confirmed that declaration, the SIU continued to make recommendations for blacklisting up to that point. Mr. Fani has already made the point that blacklisting not only involves companies or CCs, but also their respective directors and members.
Chair, Chairperson, we can't hear a thing.
Yeah, but Maharaj, I don't know. We really are battling.
It's getting worse, Chair. It's getting worse. I think there's another connection in his background. If he can just turn off whatever it is in his background.
Mr. Maharaj, if you can just speak closer to the laptop, please. Perhaps it might get better.
Right. There is no other background noise in my office, so I'm connecting directly.
Okay, just speak into the mic.
I have to speak up as much as I can. Let me know if that's any better.
Okay, for now you are audible.
All right, so as I was saying, Mr.
But
Fani,
maybe Mr. Maharaj, it's fine because there is proof of life. You can turn off your camera because the buffering may, so yeah, let's try that.
All right. As Mr. Fani has already mentioned, the recommendations for blacklisting extend to not only to companies and to CCs, but to their directors and to their members as well. Treasury has already dealt with the Prevention and Combating of Corrupt Activities Act and the mechanism provided for blacklisting in terms of Section 12, so I'm not going to dwell on this slide. likewise with the next slide. I'd like to take the committee to slide number 6. Sorry, just let me go back here. The point to be made here is that despite the declaration of invalidity of the preferential procurement framework regulations, the SIU argues compellingly that one must look at this on a purposive interpretation. In other words, we respectfully submit that it can be argued compellingly that the purpose of the PPPFR was to give effect to the constitutional imperative that the state should not be party to contracts involving misrepresentations in the broader sense. And we submit then that further support for this argument can be found in Treasury Regulation 16A 9.1, which deals with avoiding the abuse of a supply chain management system. If our argument is then accepted and then applying this interpretation, the SIU then submits that any misrepresentations made by a tenderer in a bidding process would then open that tenderer up to being restricted by National Treasury, obviously after due process is followed. And the point we want to make here is that prior to the PPPFR being declared invalid, the PPPFR was very specific in terms of what circumstances allowed for Treasury to blacklist. And it spoke about misrepresentations regarding a tenderer's BBBEE status, or misrepresentations regarding subcontracting, and lastly, misrepresentations involving local production of content. So our argument is that one must look at this purposively, and one must extend those aspects of misrepresentations in a wider sense in order to protect the state from contracting with parties where any misrepresentations are made in the bidding process. So that then brings me to the next point, which is that if the argument is then accepted, the imposition of blacklisting, or the imposition of a restriction on a supplier or on a service provider, it would amount to administrative action. And as such, the requirements of fair and procedural administrative action in terms of the Promotion of Administrative Justice Act must be followed, because it would mean that to restrict a supplier would materially and adversely affect the rights or legitimate expectations of that supplier. And hence, such process must be procedurally fair. In this regard, the Promotion of Administrative Justice Act provides for the following requirements to be met. And essentially, it means the following: that the decision maker, or the organ of state or the state institution, must give adequate notice in writing to the affected tenderer of the nature and the purpose of the proposed administrative action. The state institution must then provide the affected tenderer a reasonable opportunity to make representations. So this means then that the state institution must invite that particular tenderer to submit representations as to what its views are regarding the proposed action to be taken. The organ of state must also then provide a clear statement of the administrative action to the affected tenderer. In other words, what steps does the decision maker intend taking after the decision maker has applied his or her mind to the matter? And in this case, it would be whether or not to request National Treasury to place the tenderer on the database of restricted suppliers. And then lastly, the decision maker must inform the affected tenderer of that person's right to request reasons for any decision that has been taken in terms of departure. Importantly, once the organ of state has satisfied the departure requirements, and if the organ of state is satisfied that a case has been made out to recommend that the affected party be placed on the database, that organ of state may again request Treasury to restrict the tenderer. An important point that I must make here is that the SIU, in its recommendations for blacklisting or for the restriction, the SIU will only do so in a case where the SIU has, pursuant to its investigations, found that the evidence obtained in its investigation establishes grounds and justifies action under the provisions in the relevant legislative provisions for a recommendation to be made for blacklisting or for a restriction. Chair, I seem to be missing a slide which deals with the number of referrals made to provincial and national departments. If you could just bear with me for a second, and I will then pull that presentation up. with the correct document in it. Chair, I seem to have lost my presentation. I do apologize for that. But in a nutshell, what I can confirm is that the SIU has made 506 recommendations to various provincial and national state institutions for suppliers or service providers to be blacklisted. Now, when you look at that number of 506, and when you compare it to the 143 that National Treasury has reported on as appearing on the database of restricted suppliers, National Treasury's concern is understandable when Treasury says that it appears that state institutions may not necessarily be following up on recommendations made for service providers or for suppliers to be restricted. And our view is that this is of concern, and one then would have to then interrogate what then became of those 506 recommendations for the restriction or for the blacklisting of service providers or suppliers. Chair, that then concludes the SIU's presentation, and we are available to take questions. Once again, I apologize for the omission of the slide dealing with the numbers, but again, I can confirm that it is 506 recommendations that the SIU has made for restrictions of service providers and suppliers. Thank you.
Yeah, no, that is fine. Thanks for the presentation, but I think that we need that slide. So I suggest that you look for it. I think the breakdown is very important. Yeah. Yeah. So can you use the time to find it, because we're going to be
Honorable Chair.
Yes, Honorable Hadabe.
I think on the presentation that was shared with us, the breakdown is there on slide 10.
Yeah, I wanted flighted. That's what I mean. I want it flighted.
Oh yes, okay, cool.
Because you know, National Treasury may not have sight of that.
Yes.
And so for sharing purposes, so that's what I'm saying, because it's got the sharing rights to find it.
Honorable Chair, with your permission, and thank you very much for that. Once more, I really apologize for this this glitch. We will definitely not repeat it again. Mr. Maharaj or Mr. Lekgetho, if you could please just help. It's important that we project those numbers, because they are really broken down in terms of provinces and so on. Honorable Chair, if you can give us for just a minute, we'll find it. Thanks.
No, it's no train smash. That's why it's just that so it can be found in the meantime.
Thank you. Thank you.
All right, let us. DM, thank you very much for your input in your opening remarks this morning, and to the Acting Chief Procurement Officer, Advocate Mtibi and Bab Maharaj. So colleagues, let's field the questions then, and then we will be good to go. Colleagues, over to you. Honorable Liz, so good to have you, Mazamba. And I know that you were the victim of load shedding this morning. So yeah, we seem to be interchanging in that regard. Right, Honorable Liz, and then Honorable Siwisa, in that order.
Good morning, Mr. Chairman, and thank you for your kind words. I know you're a politician and you may have had other thoughts about me being present or not being present, but we won't challenge.
Oh, we would never cast aspersions on you. All right.
Yeah. So yeah, the electricity came on 4 minutes after 10. So I'm back online now. So thank you very much, and thank you to the National Treasury and to the SIU. Well, the National Treasury is a long time since I dealt with them, but my experience has always been a good one. not so much with the ministry. But let me just go to you, Advocate Motivi, and it's topical, and you've expressed some very strong views about it, and quite correctly so. I think the court ruling yesterday was a very big step forward, but it's just a step, unfortunately, because it has, and perhaps you can express it more clearly to me, but it doesn't appear to hold anyone accountable other than the contractor. And so we're talking about blacklisting today, and we know that that same contractor has in any event been given lots of other work all over the place, and probably won't feel it too badly to repay the profits. But actually, the whole job was simply a waste of money, a complete waste of money. It has not achieved what it was meant to achieve. And so that brings me then to the point I'm driving at, is that the court has made a very good ruling in that sense of recovering some money. But what about the officials who were responsible, for engaging a project which was not properly conceived, and not then supervising the project to ensure that value for money was obtained? Who are they? Have you got names of them? And what are your recommendations so that we can also follow up with the department? I know the minister probably is unlikely to resign, as she should, but at least the officials we can hold accountable. Thank you, Mr. Chairman.
Right, let's take, I think, colleagues, maybe if we close, I think we're good for time. Take two hands at a time, and then we can come back. So let me take Honorable Suwis and then Honorable Hatebe in the next round, if you're good with that.
Yeah, thank you, Chair, and thank you for the opportunity that you are giving me. Chair, I think most of my questions have been answered in the presentation because I was making notes as the presentation goes on. But what I want to know is that what happens to the accounting officers if it's found that they have turned a blind eye to an appointment of a restricted supplier? Because you'd find that the supplier is given a tender to do something under, let's say, as the presenter said, that the directors would not appear, but later on, after the supply chain has given a certain supplier a tender to provide the certain services, and then it surfaces that certain directors are already there. So what happens to the officials that actually turn a blind eye? Because I heard the presenter say that you find that the officials do not want to take accountability. They send their cases to National Treasury. So what does National Treasury do to those officials that do not want to take accountability? And Chair, we know we always find ourselves in the midst of, you find that a tender has already, or services have already been acquired from a certain person under an Alice name, or they change the name of the company, and then you find that the directors are still the same. And I think there's a loophole in the whole legislature that something needs to be done as to make sure that such people, whether there must be a system put in place to say whether they are on the surface or not. There must be a certain system that needs to be put in place, which means that somewhere that we need to look into the legislation, because I see a lot of loopholes, and it seems as if the National Treasury becomes frustrated about the whole thing, whereby you'd find that suppliers or the directors that fall under that supplier actually have been restricted or have been blacklisted in the past. in certain areas of doing work with government. But at a later stage, you'd find that those same directors, the same people, they appear under another name of another company, whether private or public. Then you'd find that. And I would, as the presenter from National Treasury has said, I would refer it back to the officials that do not want to take accountability and refer things to National Treasury. So what's the standpoint of National Treasury when it comes to those officials? Thank you, Chair.
Okay, thank you very much, Honorable Liz and Honorable Swiss. Let's get responses to that, and then Honorable Hatebe, you'll be next off the bat.
Honorable Chair, if you permit, I can respond specifically to the question asked by Honorable Liz relating to the important ruling that was made yesterday against the service providers who really tried their best to avoid being held to account. Firstly, by starting to challenge the jurisdiction of the special tribunal, saying it's not a high court. And the tribunal found that it's got the status of a high court and it can rule on their contract. The contract was firstly set aside. So yesterday was specifically around what is called just and equitable ruling in terms of determining what has to be paid back. So in terms of holding the officials to account, Honorable Liz, I can read further. Paragraph 50 of yesterday's ruling goes further to say, further corrective measures lie in holding the officials who designed, approved, and implemented the Bay Bridge border fence project and its related procurement process, and those who failed to take the appropriate steps to enhance the integrity of the fence to account. So the court is clear that the officials and all those related have to be held to account. And as part of the outcomes of our investigations, and we presented before to the Honorable Committee that we have referred officials for disciplinary process. So as part of our follow-up to ensuring that those are acted upon, we will follow up to get the status from the department. So it is clear that no one should be spared. The ruling, of course, goes specifically against the service providers that they cannot benefit, particularly from a profit perspective, from this irregular contract. But it's very clear. The court also clearly says the officials have to be held to account. So we will follow up, Honorable Liz and Honorable Committee, to ensure that those referrals we made for disciplinary process are processed and that are acted upon. With regards to the other question, if my colleagues at the National Treasury would probably take that part, but I mean, the question was what happens to the HODs or accounting officers who ignore companies who are restricted. Is probably part of the process. If I were to offer just a view before our colleagues come in, is that whenever probably during the tendering process, there should be an indication where it is clear whether the service provider has been blacklisted or not. The list that our colleague at National Treasury talks about, there should be a process where those kind of lists are surfaced to the accounting officers so that they can check the service providers against those lists. And if it becomes clear that they've ignored those lists, then of course it calls for consequence management. But I'll leave it here. That's really just offering a view. My colleague, Mr. Molefe Isaac Fani, if you can probably assist.
Thank you very much. Good morning, Chair, and good morning, honorable members. Good morning, Mr. Mutibi and colleagues. Let me start. Molefe will come in just now. on Honorable Siwisa is right in terms of us getting frustrated most of the time when the suppliers who have been information firstly may not be coming through in the way that we expected, and secondly when we pick up that suppliers who have been restricted have been processed through the process, and we have to account. What the MFMA and PFMA does, and which is something that we have to raise here, is that it places responsibility and accountability to the accounting officer. And as a result, there's no reason why departments have to actually throw the ball back in our court when it clearly is in the court of the service provider. As an accounting officer, I'll give you an example. When a tender is advertised, before an award is made, the bid adjudication committee, the bid evaluation committee will do all of the checks. They will indicate, and by the time it comes to me, it's expected that what I signed off, firstly, the key questions will be asked. Is the suppliers blacklisted, yes or no? Is this price okay, yes or no? Was the committee process, the process, was it done fairly and squarely, yes or no, before I sign off? But the reality is that you find that what's happening in departments, we don't have control over as National Treasury. We only pick it up when the central supplier database sometimes kicks off the suppliers who are listed clearly, because that interlinkage must be there. And it's sometimes frustrating. So I'm just echoing the same sentiments echoed by Honorable Siwisa, that from where we sit, sometimes it's a bit disconcerting that some accounting officers are not taking full responsibility when the PFMA gives the responsibility. And as a result, agreeing with Advocate Mutibi that then consequence management should be taken, and the accounting authority then must act, or sorry, executive authority or accounting authority must act. But Molefe, you may come in terms of maybe directly some other comments that are critical and necessary. Thank you, Honorable Chair.
Thank you, DG. Maybe just to close off your comment, is that in instances where the accounting officer has started the process, the National Treasury requires further information to effect restriction, and such an accounting officer is not coming forth with the information, National Treasury would not close the matter until such accounting officer has actually provided us with the information that we need. If I may also respond to Honorable Siwisa's comment with regards to suppliers reappearing, I can reassure honorable members that CSD certainly, as soon as a supplier is restricted, we flag that supplier on CSD together with the director's ID numbers. If a supplier resurfaces in another name with the same directors, such directors will invalidate the registration of that supplier on the CSD, because CSD will not accept the ID numbers of the directors of that new supplier. And therefore, if that supplier is not registered on CSD, it will not be allowed to do any work or provide goods and services to government. It is regulated in that fashion, honorable members. Thank you very much.
All right, thank you very much. Babu Somen, Honorable Hatebe. Amtolash, I've noted you.
Thank you very much, Honorable Chairperson, and good morning to the Deputy Minister and the DG for Treasury and the head of SIU and his team. The presentation is deeply pointing a finger at the accountability of the accounting officers, and it might extend to executive authorities. Looking into the stats provided by the National Treasury on the same matter, you'd find out there's a total of 143 restricted suppliers. And you look into the stats as provided by SIU from the SIU's investigations and their outcomes, the total of 506 referrals to various departments. And there's a heavy referral looking into the same statistics, which point at Gauteng, KZN, Free State, Limpopo, and the others would follow. And if we were to just take that slide alone, it begins to confirm what Treasury says, that the buck stops with the accounting officers who somewhat fail to take active steps on these companies at the time when such acts have been identified. And therefore, at some stage I've occupied that office. I know the frustration which Treasury faces to make the culprits account on these matters, because they individually remain somewhat accountable for these acts. But as I recall, there would at times come up a big file when an accounting officer is appointed, a big file which carries the details on the delegated powers to such accounting officers by Treasury. Those powers relate to the accounting officer responsibilities, which is indicative of the fact that when there is failure to meet such a prescripts as required and signed off by the minister or the MEC of Treasury in a province, such a delegation would have to somewhat be under question. It might be that there would be a stage where we would ask, when there has been any time that there's been a withdrawal of a delegation to any accounting officer through a failure to account on the basis of such delegations as signed off by the minister or the Ministry of Treasury at a particular time, because this is an indication of failure. You see, when you deal with matters of procurement, it's not only rands and cents. At times it's about life. Those who cross our borders illegally, they end up committing very serious crimes, which lead to loss of limb or life. And in that instance, the responsibility would have been in the failure of the particular authority to observe the specificity of safety at a particular time. I'm just making a reference to that border fence which has been poorly constructed. It might be the road, it might be the bridge which falls off, and many lives are lost during that time. So the summary of judgment carries the weight and points the finger to those accounting officers, which means thereof, maybe it might be necessary for Treasury to take note of that failure and probably to put up steps to follow strictly on those areas which are relating to delegating such an accounting authority to that administrator at the level of a particular department to do the right thing at the right time, to observe the law and to take these matters seriously as they perpetually move towards the substandard provision of necessary services. The question then, which goes along with such, is that how far has Treasury stepped towards ensuring that those who carry that file, those who have been assigned that accounting authority, is there a way that would make them, as Treasury, accountable for such from time to time? And secondly, there would be what is termed the accountability signed authority between the executive authorities and Treasury from time to time, whether there is observation of such in the failure which we see glaringly in our eyes in terms of this item in front of us. This might be a bit lighter. We've been sitting here. Fortunately today, there is the DG. Welcome, DG. And there is a deputy minister from Treasury. Hey, man, we've been having acting head of procurement from Treasury. When are you appointing in the final instance someone who's going to be permanent in that position? It has been time that we have had that position as a temporarily acting position. Thank you very much, Chair.
Thank you very much, Babsong. Can I request that those who have got the sharing rights to be very careful about what they put up? We were just now on a screen on Apple Music. Can we please maintain the decorum of the meeting? Just be careful what you put up on the screen, right? Honorable Hadebe.
Thank you, Honorable Chairperson, and take this opportunity to also welcome the Deputy Minister, Dr. Masondo, the DG, the entire staff complement of the National Treasury. We also welcome the head of the unit, Advocate Mutibi, colleagues, comrades, and fellow compatriots. Chair, before I start, let me thank Advocate Mutibi for sharing the outcomes of the Bay Bridge saga. Chair, I think this once again, it demonstrates the importance of SCOPA and its role in ensuring that, Chair, we root out corruption and those that ought to be held accountable are held accountable as such, and we expedite the consequence management. Clearly, our visit or oversight to Bay Bridge was not in vain, Chair. And I think we need to insist from this meeting, Chair, that SIU expedite the process of consequence management into those officials that have been implicated as having contributed to the wrongdoing, Chair. I think we need to be clear and unequivocal that washing line that is purported to be a fence ought to be removed and replaced with a proper fence, and those that are responsible, the cost should be incurred by those people. We don't need that washing line, Chair. We need a proper fence. And as SCOPA, I think we are vindicated in our quest to root out corruption. I thought I should stress that point, Chair, when it comes to this matter of the Bay Bridge, especially the affected officials. Thank you once again, Advocate Mutibi. Even though in this committee, it is not our practice to applaud the fish for swimming, but in this case, I think credit must be given where credit is due. Now, Chair, let me go back to the issue at hand and explain, Chair, our expectation as this matter came to our attention. We were concerned, Chair, as it is evident from the number of referrals, which is 506, vis-a-vis the restricted cases. We wanted National Treasury and SIU to assist and tell us what are the challenges that are confronting National Treasury to move at a slow pace in restricting these companies. What could be the challenges? What are the bottlenecks? If there are any lacuna in the system, what have they done to address such a lacuna or a loophole? That I did not get, Chair, and I'm still interested in finding out. Since the saga of PPE fraud and corruption, there were several instances where SIU made referrals. Some of these referrals date back to 2 years, 12 months, and the presentation indicated 14 days that must be given to service provider, 5 days. Yet we were furnished with the information that give a reflection of cases sitting with National Treasury for more than 24 months. We need a clear understanding. Why do you have cases in your possession that are staying in your drawers, wherever you keep your cases, for more than the prescribed time, as your presentation has alluded to the procedures that ought to be followed? Now, coming to the next question, Chair, from the presentation, they've reflected that indeed contractors don't take lightly of the process of restriction. As such, they often go to court to challenge such restriction. I'd like to get a sense of how many contractors that were investigated and finally came to a conclusion that they need to be restricted as per the evidence before those that were investigating. How many of those contractors went to court? Subsequently, their cases were successful, and how many went to court and the court upheld the decision from National Treasury to restrict? And those that were successful, what were the common reason for National Treasury to lose those cases? How many cases were lost due to non-adherence to procedural fairness as outlined in the presentation? And what has been done with those official or accounting officers who have failed to adhere to procedural fairness, Chair? I think today we wanted to get those details and those steps taken and people responsible for ensuring that such referrals are adhered to and procedural fairness is adhered to. And if there are any who have not been doing their work and who have been lazy in ensuring procedural fairness, we need those names, and consequence management must be implemented expeditiously into those officials. So we need those responses, Chair. And I'm sure it is there available at the disposal of the National Treasury, and SIU can assist in this regard. For now, Chair, let me stop there and gather my thoughts in terms of my notes. I've got a lot of questions. Let me pause there for now. Thank you, Chair.
Okay, no, that's fine. Let's get responses to that. And then Mam Tolashe, you and Honorable List, you will come in. So responses to Bob Somyo and Honorable Hatebe.
Well, thank you, Chair. Chair, just to respond to Honorable Hatebe, it could be the expectation of the committee, but that's, Chair, that's not what you had in your letter to us requested us to do. A list of names and cases that were successful and that were not successful. That was not part of the brief in terms of what we expected to do. We were, the letter is clear in terms of process, and that's why we focused on the process that we follow and what will it take, and explaining that, and obviously giving you high level, but not the details that Honorable Hadebe is looking for, which I guess obviously we should be able to gather. But again, let me take you back to the process. In terms of the process that we follow, it's not a process that is led by us. In terms of we have to be informed. The work must be done by the department, and the presentation is clear in terms of the process. And therefore, accounting authorities and executive authorities and accounting officers have got a fundamental role that they play in terms of blacklisting and in terms of sanctions, etc. The law, the law as it currently is, does not give the National Treasury sanctioning powers at all. And that's one of the criticisms that not only to Treasury but to the whole of the state from the time we wrote the PFMA in 1999, 98, 99, that the PFMA, the Treasury does not have teeth in terms of what we are able to do insofar as sanctioning powers are concerned. Or we can only recommend, we can only expect that the executive authority and accounting authority may act in the case of public entities and state-owned companies, because there are boards that will act when a wrongdoing has been found out. Then there obviously are certain responsibilities that in law that the PIC, the SIU has, and also other law enforcement agencies which have to happen if there's issue of criminality, which in the course of investigation and the cause for the reasons why in the first place a company has to be blacklisted. It only ends there. So that delineation of responsibility is quite very critical in the way we exercise this responsibility in the Treasury, because clearly there are loopholes in the way the current legislative framework is written and on these matters, and also in terms of the regulations that we can only follow. So if the committee is asking us as to what have we done with a certain accounting officer who has acted in a particular way, I can't answer that. I can't tell the committee what we have done insofar as consequence management for that particular accounting authority or accounting officer, because I don't have, there's no power given to the National Treasury to do that. So the issue in law there is quite clear and quite critical. So I just thought we have to mention that. And the lacuna, is borders on these things, in terms of how I understand Honorable Khadebe. And and again, as we are preparing for this, I was asking the team, I said, look, what is important is also to know that some agency in the state will identify certain wrongdoings. We will bring that to the attention of the said executive authority. And if action is not taken, then obviously consequence management across the system must be applicable. But what we cannot obviously not do is where I'm seated, threaten the accounting officer with certain sanctions, because the National Treasury does not have in the current legal framework the responsibility and the authority to act. It's a flaw, call it that, in our system, and that's how unfortunate things are at, because then we will be taken on task if we exceed our powers and functions as the National Treasury, as you can imagine. Honorable Somyo, I think you mentioned a number of things that are related, but of course, Mr. Molefe can come. But I think when the Deputy Minister started, he did indicate the reasons, the process, and indicated that we had interviews. The committee made recommendations on the two positions, and the process obviously unfolding until finally a cabinet appoints. But at least a good indication of the process to fill the vacancy is that interviews were held, and we were part of that. And then so finally that a recommendation was made, and the process to finalize the appointment is ongoing currently. Molefe, and you can come in.
Thank you, DG. I think you covered quite all the matters that were raised. Besides two honorable members, I have to indicate that at the current moment, there are no pending matters for restriction that are sitting with National Treasury. If they are fresh ones, but all the matters have been resolved. If there are instances where there are disputes, such disputes mechanisms are being followed, but it's not that there isn't any movement. I am only aware of one matter that's disputed. Other than that, we are, as National Treasury, have resolved all the matters that have been referred to us. I think that was one area that the DG did not touch on. Thank you, Honorable Chair.
Honorable Tolashe and Honorable Liz, and then Honorable Latabe will come back.
Chair. Chair, can you hear me?
Yes, Honorable Mente, we can hear you, Fighter. I'm not sure what's happening with the connection of the chair.
Oh, okay. Thank
Yes,
you.
ma'am.
Yes. No, Chair. I wanted to.
Is next.
I want to come in on the. All right. On the response from Treasury in terms of what then becomes a role of Treasury when accounting officers are not carrying their obligation and their responsibility to ensure that there is nothing which is procured from those that are affected in terms of being sanctioned or otherwise found to be corrupt as service providers. And the DG seems to be helpless when it gets to that, and I do not understand. Because even if it's not for the PFMA, but in the PFMA itself, with the delegations powers that the National Treasury has, and 2C number 2 and 2B number 2, if ever that which you have given an obligation to any of the accounting officer is outside the prescripts of the law, then it means that you did not perform the assigned duty to the level which is expected of you as an accounting officer, because accounting officers cannot come back and say there is no law I have breached. You have breached the law if ever you performed duties out of your prescript, and you did not carry the obligation to ensure that the people whom you are allowing to access the coffers of the state are the very same people that have been blacklisted on the other entity, and therefore failure for whatever department entity which was given money by the custodian of the purse of the state, which is National Treasury. It cannot be that National Treasury cannot do anything, because you are the custodian of the purse. And once you give the responsibility to an accounting officer to look after the purse on your behalf, and they fail to carry out their duties, therefore they are in breach of the law. It doesn't have to be said in the PFMA, otherwise we'll have to list all the transgressions in the PFMA, which the transgressions cannot be listed as it is, otherwise we are going to be sitting with loopholes all over. It's enough for you when you have entrusted an accounting official to perform the duties which are assigned to them by the Constitution. The Constitution did not assign them a duty of not ensuring that directors of a company which is blacklisted are not found in a new service provider company. So it cannot be that National Treasury cannot do any other thing. The second part of it is that it's criminal. And therefore it cannot be that if internally you're failing to do something, there cannot be a criminal procedure that then follows. Thank you, Chair.
Right, Mam Tolashe. Thanks, Honorable Mentor. All right, Honorable Liz.
Thank you, Mr. Chairman. And it's encouraging. Thank you, Advocate Motibi, that the consequences for officials was in the ruling, and it's good to hear, and that you're going to do your bit. But Mr. Chairman, I think we must also do our bit, but that's probably for a different discussion. Mr. Chairman, I was going to ask about the Chief Procurement Officer, and so thank you for that question from Honourable Somio. It really has been a long time, and yeah, we miss Kenneth Brown, but I do hope that the recommendation you have made, Dondo, is a good one. But we will wait law. But let me ask you specifically, the agreement to dispose of 51% of the shares of SAA to a Takatso consortium, has that deal been approved by National Treasury? And in order to do that, I assume you would have seen it, and that all the proper procedures have been followed. Thanks, Mr. Chairman.
Let's get responses to that, and Honorable Hadebe will come in, and then I think we will bring it to an end there.
Thank you very much. Good to see Mr. Lees too again after so many years. But I see every time Chair Mr. Lee sees me, he sees SAA and the challenges. And Honorable Mente has always made sure that I perform my functions, and I'm happy for that guidance, and thank you very much. All I was saying, Honorable Mente, I'm not saying we are powerless per se, but I was talking about sanctioning an accounting officer or disciplining an accounting officer. That. But in terms of other powers and functions that we are there, whether from the Constitution or the PFMA, we have to exercise. We have to be inquisitive in the questions in terms of the quality of spend, and if the quality of spend is not up to speed, what we normally do, and this we do all the time in other committees, in various portfolio committees, in the appropriations committee, whereby we indicate when we talk spending, challenges and concerns that we have and also what we normally do in our section quarterly reports that we publish, we outline certain key challenges that our analysts are picking up as engaged with. But in terms of disposal of assets, this is a process, and unfortunately, for the first time in many years, I will not be able to answer you at this time, Chair. But I commit to responding in writing to the Chair, to you, Chair, through you to the committee on this particular matter around the disposal of the 51% of SAA and the process to date. I want my answer to be complete in terms of process, in terms of when we were approached, in terms of what letters we exchanged between ourselves and the Department of Public Enterprises, and we'll have to make that knowledge come into. And if need be, Chair, we will be more than happy and ready to come and appear before you on this matter with the Department of Public Enterprise and account on how
we will not close it until it is fully completed. We also look at issues of rehabilitation of suppliers before we delist them to ensure that introduce delinquent suppliers.
Yeah, muted, Chair.
Yeah, Chairman. Tata Wedwa. Let me take off your screen, Chairperson.
To make Umazambane, Honorable Lees, happy. And so he is happy with your response. I think it is now just a colleagues.
Now we're just hearing about happy people, Chair. We can't hear you at all.
All right, that is strange. All right, I was saying, DG, Honorable Lisa is happy with that response. It's just a matter of determining a time frame as to when you will be able to submit the comprehensive response that you spoke about. I see Honorable Hardebe, and you've got your hands up. Are those historic hands or are they current hands?
Current, Chair.
Okay, you may proceed then in that order, Honorable Hardebe and Honorable Mente, and then we will bring it to an end in that regard.
Thank you, Chairperson. I am confused and perhaps I need clarity from the SIU in relation to these 506 referrals, because when National Treasury responded, they are indicating to us there are no pending cases in front of them. Where are these cases located and what's happening with those cases? I'm working under the assumption that there's a central database where everything that is done by national departments and provincial departments or provincial treasury in terms of tender award gets to be fed into that central database, and the movement will be monitored, acted upon as such. So I would like to get a clarity from the SIU in relation to these referrals. National Treasury is telling us clearly that there are no pending cases of restriction at their doorstep. But the second question, Chair, that I would want to ask, as indicated by the National Treasury, that they don't have all cases in their possession where persons have been convicted by court of law and the restriction were imposed. And perhaps you excuse my ignorance, but it is my understanding, Chair, that when courts delivers judgment, whoever is responsible to act or sanction such sentence, for example, when a warrant of arrest is issued, a police minister or SAPS will be informed to act upon and follow that warrant of arrest. Now, in this case, when the court delivers a judgment that this person or this company must be restricted from doing business with the state, don't they inform those that are meant to enforce and impose restriction to act as such? If they don't, that will be strange. Over and above the accounting officer and accounting authority bringing matters to the attention of the National Treasury, does National Treasury have ways and means of ensuring that all cases where court has pronounced such cases are dealt with? In other words, what have you done to ensure that the lacuna that currently exists or the loophole that exists in you not having all the cases that speaks directly to you, that matter is addressed? What have you done to ensure that such takes place so that we avoid those that have been found guilty to continue to benefit unduly, even when the court has ruled otherwise in terms of their conduct and behavior moving forward in relation to the state? I'm very interested in that, Chair. But secondly, I would want in the future, Chair, to really get the sense of where the accounting officers have failed to deal with this matter procedurally as prescribed by the presentation. Thank you.
All right, Honorable Mente, is this a new hand or a historic hand?
No, it's a new hand, Chair.
All right, sure.
Yeah, Chair, I have one question which part of it Honorable Hadebe asked about, but there was a meeting we had early last year with National Treasury where we spoke about the central procurement system, and we promised that it's underway. I want to check how far is that system, because it will help us to arrest a lot of these activities that take place where individuals duplicate documents and just change the name of the company. So I wanted to know that, Chair. Thank you.
All right, let's get those final responses. DG, your SA,
No, thank you, Chair.
your SAA.
No, Chair. Eskom ubhalele kuwe. We're struggling to hear you.
Balwa nami phela ngoba ngisuke ngathetha ekuqaleni. I was saying, DG, the SAA responses, 14 days, and then responses now to Honorable Hadebe and Honorable Ment.
Thank you, that Chair. Thank you. We note the 14 days. We will certainly comply to that. Honorable Hadebe, I think, look, you are right. There's no mechanism currently that is in place that I can know as Treasury what the decisions of the courts are. If there's a court sitting currently in Northern Cape and in Mpumalanga at the same time, I wouldn't know, and there are many such, if you can imagine. But one expects that maybe it's something that we need to relook in terms of bringing and what the role of the provincial treasury is, because they are closer to the action in a province, they're closer to the action in a particular municipality, and the issues will be very relevant. So, and as much as we control the list and the register of these blacklisted companies, how we have to interact on these matters with provincial treasuries as a way forward, as a new lesson that clearly you are outlining to us, and that the new challenges and the new cases as they develop, and they become many, by the way, because when we perceived this legislation back then, and we wrote some of these treasury instructions and instruction notes, we would not have taken many of the things that we are experiencing today into account. So constant review, constant check of these things, and new ways of doing business should be the order of the day. I take that, and I take guidance, Chair, and that's the value of this engagement today, because clearly there are many loopholes in our current arrangements and on the process itself. Because, and Honorable Mente is right, if we're waiting for an accounting officer to come and report himself or herself, that won't happen. So we have to find a way and the mechanisms within departments and how we interact with the departments and the organs of state on these matters. So I don't have a response for you in terms of what we're going to do, but all I have is that we will have to lift this issue up, Honorable Hadebe, and take it forward in a manner that will enhance the process and enhance accountability, and also ensure that action is taken where it's due, and also revise our processes. When an entity like the SIU has done all the investigations and has issued a report that suggests that Andrew Squared, which is my other name, Mr. Mutivi, is Andrew, so you and I share the names. If Andrew Squared Pty Ltd has been identified by the SIU as having flouted the law and having done certain things, immediately, without Molefe and the CPO waiting for that department to act, we must have the authority as Treasury to immediately sanction that company. And so the current legislative arrangements and process doesn't allow us that. We will have to then wait for the Andrew squared, which department they did the work, and that department have to inform us to be listed, and half the time you won't find that. So I think this conversation, as I say, calls for us to do work differently and to be innovative and new way and new instructions that we must think about how we're going to manage the blacklisting process forward. I take that. And Molefe can talk about, the process. We're not talking honorable. We didn't indicate that we want to go back and centralize procurement. No, I don't think that was the intention of centralizing procurement, because it was going to be cumbersome and we don't want to go back to the old state tender board days. But what we're able to do, we're able to look at lessons. There are certain processes, and Molefe can go into detail with talking about transversal nature of certain contracts and certain commodities and how we're able to do that, including the central supplier database and how it functions and how we're able to also deal with certain things whilst we continuously modernize our procurement process. Molefe, you may want to maybe talk a little bit about the point that Honorable Mentor was asking us about, which is essentially, she was mentioning the central procurement system, but that's not what the intention was. Maybe you can talk both to your day-to-day and how you go about the CSD and also the transversal contracts. Thank you.
Thank you, Liam. Through you, Honorable Chair. I think what Honorable Mente was alluding to is government having a single ERP system, a repository system that would enable National Treasury to do oversight responsibility, ensure that reporting happens uniform across government. The intent is not to centralize procurement, but to ensure that the organs of states like National Treasury that has an oversight responsibility has access to procurement activities within organs of states. That we envisage that we would be able to achieve through an IFMS system once it is fully completed. But what happens outside the system, issues of reporting, specifically when we look at the matter that we're talking about this morning, where we're talking about restriction on suppliers, these are the things that happen outside the process, which needs to be fed into the process once they have been reported. The system would deal with procurement of goods and services, but we would not seek to regulate behavior of those that do procurement. And that is something that we need to seriously look into, independent of whether there is a system or not, instilling discipline of officials that are trusted with ensuring that procurement happens in line with the promulgated prescripts, and that consequence management is taken care of. Certainly, even if you've got an ERP system that deals with procurement, behavioral issues would still be managed differently, and the accounting officers are responsible in terms of their PFMA to ensure discipline of all the officials that are trusted with procurement activities within government. Thanks, Honorable Chair.
Okay. Right. I think obviously progress is being made. The intricacies of the law are at play. But
Chair?
I hope I'm audible. Yes, Honorable Hattab.
No, I had asked the SIU
my
to respond, yes,
Sorry.
on the issues of referrals. Where are they sitting?
My
if
apologies.
National Treasury is not having any pending.
The head of unit is eagerly waiting to respond. All right, over to HOU.
No, thank you. Thank you, Honorable Chair. Honorable Hadebe, thank you very much for that question. As you would have seen in our slides, there's numbers that we are showing per province. So all of those referrals, and perhaps we can even enhance the slide to show the age of the referral, when was it sent and all of that, and then resent to the committee. But all of those would have been sent to the accounting authorities or accounting officers, as the case may be, with the expectation that as accounting authorities or accounting officers, they should then take the necessary steps to kick off the process, to restrict the service provider, in line with what my colleague, Mr. Maharaj, and Mr. Mlefe has presented as the process to blacklist. Now, in terms of comparing the statistics, Honorable Hadebe, so from where we sit, all of this would be sitting with the accounting officers or accounting authorities. So I would then probably propose, which we can do with our colleagues at Treasury with the DG's permission, that our team and the Treasury's team can then compare the numbers, check the numbers that they have and have been completed, which department or which state institutions they came from, and we can indicate which state institutions have we sent these numbers to, and where are they in the system, in the process. Where are they? I remember Honorable Hadebe in one of the meetings we had with the Honorable Committee, the pointed question you had was, how long does it take to blacklist a service provider? And I think that question is still a moot question, because each and every process really depends on the due process that's followed, how long it takes to give the service provider the opportunity to present, and he writes back to the accounting authority and so on. So we will then indicate in our engagement with Treasury, these are the numbers, this is where they've been sent to, which numbers do you have, where have they come from, and where, if there's a balance of numbers, where are they in the system? And then we can possibly follow up properly with the relevant accounting authorities or accounting officers. Thank you.
Honorable Hadebe with an H, are you happy with that?
Yes, no, through you, Chair. Can we then give the process 14 days to give us feedback and action taken if it is found that the failure is in relation to accounting officers not promptly dealing with these matters? We don't want the laissez-faire attitude, Chair, in effecting consequence management. Can I suggest 14 days, Chair, for us to be given feedback? And I fully concur with the proposal made by Advocate Mutupi.
Thank you, Honorable.
Okay, no, that is in order. Tolash is having, well, all right, I see that, is that a new hand? Also, it's a historic hand.
No, it's a new hand, Honorable Chair. Just a follow-up to the response for Honorable Hadebe.
Okay.
You see, the difficulty stands that the main accountability in this sense rests with a departments or provincial related departments under investigations. And those referrals have been sent to them. Advocate Mutibi could shape the report together with Treasury, and that report would still point that the referral was made to this and that and that and that. That's where things are. It looks like if we want to see further action and accountability, we need to find a way of getting into where things are, and where things are with those departments which are affected. So the compilation of the list, the direct involved departments and sectors ought to be followed. And in this instance, it looks like Treasury is unable to follow that because the referral should be made to them by that specific department. it might be that on receipt of such a report, there needs to be some form of action which is directed to those departments and make them account for their failure in as far as such a referrals are concerned. So my view is that they will only be assisting us to know, but further from such would need to sit and frame a way forward, which is going to assist to enforce that kind of accountability to various appointed departments or sectors. Thank you, Chair.
Okay. No, Babsome, I think I agree with you. There is a seemingly disjointed implementation of the blacklisting. In that one, of course, National Treasury is expecting that work is done of this implementation in other spaces and so on. But you see, the issue of individuals registering new companies is one thing. But the fundamental point is that we are not really here speaking about companies, because it's very easy to register these things. It's a blink of an eye. Ultimately here, what we are really wanting National Treasury and the law enforcement agencies to look at is the blacklisting of individuals. Because company names and company registration is an administrative exercise. It's a desktop exercise performed by people. If company one is blacklisted, then they just move on to the next one. And so you've got repeat offenders in different outfits. And that is ultimately where the challenge is. So I think National Treasury really needs to apply its mind on an implementation plan, a monitoring plan of this blacklisting arrangement, which is going to be watertight. We're not expecting National Treasury to lament. Where there are, of course, areas where parliamentary intervention is required, then National Treasury introduce those amendment bills if it has to go to that extent. Unfortunately, we as a committee are not allowed by the rules of parliament to introduce, bills and amendments and so on. But you are in a position through the Standing Committee on Finance and to do that if it comes to that. So I'm really calling for a thorough assessment of the entire arrangement and to tighten and close the loopholes which currently prevail, so that the issues that colleagues are raising will not need to arise moving forward. And so it really then goes to the law enforcement agencies actually being more aggressive insofar as personal liability is concerned on these acts of corruption that take place insofar as these bogus companies are concerned. Because really, the issue of Mahwa construction that we are all happy, and I think Honorable Hadebe, you speak for all of us, when in the assessment that you make, that the kind of pressure and consistency we have applied on that matter has yielded these kind of results, and is, as far as I'm concerned, a case study on how we need to do things, because a focused and targeted intervention like that one, we see it to a logical legal conclusion as this one is helpful. But the issue with Mahwa construction is fundamentally that you're dealing with individuals here. This company has been doing business with public works for the longest of time, over 10 years, over 15 years. And so they become part and parcel of the furniture, and the individuals end up becoming the systems. And that is the risk. And so I think really National Treasury and SIU, I think moving forward, that's the kind of proactive steps we are looking at. This has to now become a personal agenda, for people. It must bite people. Otherwise, we are in trouble. But I think let's leave it at that. I think, colleagues, we've got a sense that work is being done, and all the submissions that are required, particularly the specific areas around SAA, which has been raised, and also on those that have been blacklisted. But I think also importantly, we need to know where are the areas of resistance. Which are these accounting offices and or departments or entities that are resisting, so that we can call them in. I think Gauteng and KwaZulu-Natal in that slide are also leading in that regard. And so at least we've got a particular sense of where to focus. But ultimately, there has to be a paradigm shift, that the blacklisting must not be a cosmetic exercise in the sense that it blacklists names of companies, but it must blacklist the associated persons who are involved in these acts of corruption. So, colleagues, I'm going to hand over to the Deputy Minister for any concluding remarks that he may have, and then we will call it a day. Principal,
Chair?
over. Yes, Honorable Debe.
No, before, can we then resolve that we first start with Gauteng and KZN as they are the biggest culprits in this relation to come and account before us?
Okay, sure, no, that's fine. System would then take note of that, and we will find a date for them to just deal with this thing. That's perfectly in order. May I call upon the principal to make concluding remarks? Deputy, over to you.
No, thanks, Honorable Hlengwa, the chair of the Committee of SCOPA, and all the members for the opportunity given to us to discuss this important matter, and we'll definitely come back to you on the issues that require further explanation, such as SAA. And Chair, we will definitely heed to your advice that where we can, we should recommend certain legislative amendments, including issuing instruction notes. And I think we'll also take seriously look at the recommendations that also came from the Zondo Commission, because a number of things have also come out of that commission, which as National Treasury and the government as a whole will be looking at to make sure that we deepen and strengthen good governance in our system, including some of the recommendations, views that you've expressed around looking at individuals beyond just blacklisting companies. So thank you very much. This has been a very useful and very fruitful exercise, and we've taken note of all the recommendations that you have forwarded to us, and we'll definitely make sure that we follow up on those. Thank you, Nyabonga Slal, and members of the committee, and DG and your team. Thank you so much for enabling the team to have insightful conversations on these matters. Thank you very much.
Right, thank you very much, DM. All right, let me take this opportunity to thank the DM, Head of Unit, DG, National Treasury, SIU, and AG for your presence this morning, and the media who constantly are reporting on the work that we are doing. Thank you all for your attendance this morning. Colleagues, we have got an oversight, one-day oversight visit on Friday to Western Cape Prasa, and Ulungisa will be communicating those details during the course of the day. I know that there are some apologies If they are further, please advise. But for now, that oversight is proceeding. And then, of course, in the last week of March, we are going to ESCOM as a follow-up visit, amongst others, to our 2019 visit to Medupi and Ngusile and others. And as I said, it's opportune that we actually go to ESCOM, because quite frankly, the situation at ESCOM is completely untenable and poses a fundamental risk to every aspect of South African society, including but not limited to the economy. They are a threat to national stability. This can't go on. And as I said, this issue of load shedding is not just a willy-nilly default position, knee-jerk reaction. Which I know there's a problem with load shed and just deal with it, South Africans, tough luck. No, it has to run in tandem with consequence management, political accountability, amongst others. So colleagues, that's that. Sistombi and Goodben will communicate for next week's program. So colleagues, thank you very much. And Babasomi and I, 12:30, committee chairperson's meeting will be starting. So I think I have to thank you, colleagues. And on that note, the meeting stands adjourned. Thank you.
Thank you, Chair.
Thank you. Thank you, Chair.